Hello, everyone, and thank you for tuning in into my presentation in regards to the New York Times versus Sullivan Part 1 defamation case. After in-depth research involving the case of New York Times versus Sullivan, I have come to a clear understanding of the defamation term and how ideal law practices involving it. New York Times versus Sullivan's case distinctly shows that although J.B. Sullivan's case was not verbally stated, the published article, however, insinuated that he was a part of the information provided. The parties involved thus far through the case is, as mentioned earlier, L.B. Sullivan, former commissioner, New York Times and New York Times Publishing Company. Now, the question is, why did Sullivan feel that his reputation was at stake? Well, Sullivan claimed that the advertisement was referring to him directly because he had connectivity in regards to police department in Montgomery, Alabama. Elements of defamation. Now, there's many different elements as far as defamation, but the couple points that I wanted to point out is implying the information was factual without providing liable cause, actionable proof of malice. The jury found the case libel per se. Now, the Supreme Court's decision. I just want to piggyback on the jury found the case libel per se. There was actually an interview that was done with, I believe his name is William Parker. William Parker distinctly stated that although Sullivan's name wasn't mentioned, it was pretty obvious and pretty consistent that he was being targeted, or it looked like Sullivan had some involved connection with the actual article because he was the face of the police department. Now, when you're the face of a police department or any organization within the state or federal law, it will look similar that, that's just like saying Donald Trump didn't offer Republicans to make a pardon out. Now, clearly, he's the face of the Republican Party, so anything that's said or done in regards to them, it is the face of Donald Trump, even though it goes through many different, units. So I would say with the testimony from William Parker, it kind of solidified that it was actually the New York Times issue as far as involving Sullivan in the first place. It was a demeaning to his character, and it cost him damages, in which I'm pretty sure it caused issues at his home, his friends, and his other commissioner colleagues to say, hey, what's going on? Is this actually you? It can cause untrustworthiness. And as many know, when you're in a public figure, it can be very hard to sue yourself and show like, hey, this isn't actually me. It wasn't his fault. So with that being said, the Supreme Court came to a decision that the claimant's claim of defamation was liable because, once again, libel per se has been established. The defendant has no defense as to state the facts that were true in regards to the accusations, as if Sullivan had some involving party with the New York Times Publishing. J.B. Sullivan won the case and was rewarded $500,000, as I mentioned earlier, for damages, because now it's almost his reputation is at stake, and it's not liable. So I believe that case was well earned and deserves. He won the case because it's not fair defaming someone to publish an article. I don't feel it's up to stake, and it should be much more proprietary things, taking place with the consequences of doing so. That leads me into our next slide, which is Gertz versus Welch, Part 2 defamation case. Now, the parties involved with this case is Robert Welch, who's, a publishing company, I take. And Gertz, he is not a public figure, and I'll get to that later in the PowerPoint. He's considered a private party. Now, let's go over, before I piggyback to, the statements of defamatory, let's just kind of idealize what is public party versus private parties. Public party is mainly when a defamatory message is being sent out to the public and it could possibly damage, as far as a public figure, a superstar or a celebrity. That is considered a public figure. A private party is more so not really popular. No one's really aware of it, but they're there. And I have comments in regards to that, but we'll get to that later. So the alleged defamatory statements, got choked up there. The statements insinuated that Gertz was involved with criminal activity and he was a defendant for a case involving a child murder. Now, yes, he was present as far as the case regarding the child's murder, but although he had that case, that nowhere insinuated that he had something to do, or at this point, reading through, the 40 pages I had of the case, it doesn't really show me why his criminal past was brought up. For example, like his criminal records, it was no facts and no evidence to show the reason why his past or criminal records was even mentioned as far as a publishing article. So that really concerned me because with Welch's, I didn't understand the point of bringing it up, although it's a very sensitive case. However, how did the allegations affect Gertz's reputation? In many ways, as I discussed earlier with the Sullivan versus New York Times situation, Gertz endured out-of-pocket loss. He had to come up with funds to even file a lawsuit and to go back and forth to court, to hire a lawyer, to everything. It costs a lot of money to get involved in the court system. You're paying them for their time, and you're paying for a lawyer that should be dedicated to you and getting your work done. So Gertz endured a lot of out-of-pocket loss. He also endured impairment to reputation. His reputation is at stake. Any clients that he could have possibly had going forward, that was possibly ruined, or they're a bit hesitant to work with him, which means his financial loss, that was increasing. I can only imagine. Humiliation is a pinpoint. I mean, my heart yearns for this guy because, humiliation, to even have a record of something, if the facts is correct, what does it have to do with now? Like, why is it even discussed or mentioned? If that was something in the past, everyone has a past, or if the allegations were true or false, I feel like the company of Robert Welch, they should have went to him directly and discussed with him a couple things that they heard about or a couple of things that they seen before going out and publish. Now, last but not least, which I sort of cling on most to, is mental anguish and suffering. Now, nowadays in the world, it takes the smallest things to cause mental unsteadiness, such as anxiety or stress, and to go through a situation of defamation, of someone just demeaning your character and possibly falsifying information, can certainly damage your brain or cause you to lose sleep, which means it's causing you to be grumpy and angry, not being able to work efficiently for the clients that he probably still had at the time. So mental anguish and suffering, that was definitely one of a big circumstance that Gertz had to endure as far as his reputation being at stake. Now, common law, and I put this picture here just to show a deeper understanding as far as the Gertz and Robert Welch case. As it reads, under the First Amendment, there is no such thing as false idea. However, pernicious in opinion may seem, we depend for its corrections not for the conscience of the judges and juries, but onto the competition of other ideas. Now, with that common law, it set an idea for Robert Welch that they're pretty safe as far as the perceptions or the rumors of the criminal records. It kind of solidified them in that being. What would I have done differently? So, as I kind of touched on earlier, I definitely would have had an interview with the client in regards to what I've heard, or what's truth and what's false, before I publish anything. Although it's a private party, they still deserve the respect and the well endurance of solidifying. So having a meeting, asking hows and whys this may pertain to them, and it's a possibility to be published. So I would like to get a great understanding. Now, Florida defamation law. Florida is a defamation per se state. The defamation statute is listed for 2 years. Allowable Florida defamation damages is as follows: actual damages, compensatory damages, and punitive damages. Now, I can relate what I have learned from Sullivan and Gert's law studies in the communication industry by making sure I thoroughly do my research when it comes to publishing or discussing another party without their presence, rather to assume, request an interview to clear any misleading or compromising information. Last but not least, reassure the third party that the intent of publishing is not to demean or to humiliate them. And I can definitely say from all of my research, that's definitely, I feel like, has been the most issue is demeaning or humiliating another party. And it's almost as if it's intentional, because who in their right mind would publish an article that can be so harsh to another? Or we're all human, so we all know anything we say or do can likely affect another. So to publish it out to the world, I would much respectfully so touch bases with the person it's in regards to. And most importantly, I have attached my references in regards to my case. Thank you all for your time.